is not a company, is still what a separate legal person. Incorporation, once the company has been validly incorporated, the company is a separate person on its own, provided that there is no fraud. It is where there is fraud that incorporation will not still make a company to be a separate legal person. And then you hear the court saying that no one needs to trust a limited company unless he so pleases, and that before he does so, he can ascertain if he so pleases what is the capital of the company and how it is held. And I remember that one of my professor was also telling me that in that case, if they had done that, if the creditors had done that, they would have seen that, oh, Aaron Salomon is one that has the controlling shares. And since it's a limited company, they could have, and they knew that the others had just 6 shares. So they could have gone ahead to enter into some sort of personal contract with Aaron Salomon that, okay, fine, before we are going to contract with your company, before we are going to deal with your company, you're going to give us an undertaking that in the events this company gets liquidated and the assets of the company cannot defray the company's debt, we can hold you responsible. So meaning that you would have turned Salomon's limited liability status into some sort of unlimited liability. But then they didn't do that to protect themselves. They didn't even check the register. So how would they have done it? How would they have done that to protect themselves? So the court said is that this does not in any way stop the company from still existing, and that it does not stop a company to actually have one individual that is controlling the company. It does not stop one individual that is controlling the company. And the court said, well, since Aaron Salomon had not done anything dishonest or anything unworthy to the company, then also that the company suffered a great misfortune without Salomon's fault. So all the company responsible, leave Salomon out of this, because you were dealing with the company, you were not dealing with Aaron Salomon. So the court was more or less saying that if there was no fraud, then you cannot be claiming to say you want to lift the corporate veil. Do you understand? So that is what the court was saying, and this is practically all I feel like you should know about the decision in Salomon and Salomon. So I hope this helps. I hope this helps us, because if we do not understand the case of Salomon and Salomon, it may be very difficult for us to understand corporate lifting or piercing the corporate veil of incorporation. Lifting or piercing the corporate veil of incorporation. Okay, yes. May I also point it out to you that Lord Asbury, when Lord Asbury was also delivering his own judgment, he said that, well, where there is no fraud, a company, once incorporated, is a separate legal personality with its rights and liabilities appropriate to itself. So this company has its rights and liabilities appropriate to itself, and that the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. He said that supposing you even accept that the Court of Appeal was right, that Salomon created the company as a mere scheme for him to carry on business in the name of the company, he however noted that even this cannot be said to be contrary to the true intent and meaning of the act. So I can only find the true intent and meaning of the act, and that there is no way the act said that, okay, one person cannot set up a company where you have overwhelming shares, and that is setting up the company so that you can enjoy the LCLP of the company. So even if you are setting up the company as a mere scheme for you to be able to carry on business and enjoy its LCLP, so that is the very reason why that is exactly the meaning of setting up a company. That's what distinguishes a company from a partnership and a sole proprietorship. So it is because you actually want a situation where the company can stand on its own and your liability will be limited to the amount or that you have contributed or to the company, or that you have undertaken to promise to contribute to the company. So he said, well, there isn't really any case for you to say that Salomon should be held liable and then the company should be bypassed. So this is all I have for you as far as the case of Salomon and Salomon is concerned. And may I also sharply point it out to you that Atkinson J, in the case of Smith Stone versus Knight Limited, in the case of Smith Stone and Knight Limited versus Birmingham Corporation, a 1939 case for All England Law Report 11 page 116. He said it is well settled that the mere fact that a man holds all the shares in a company does not make the business carried on by that company his business, nor does it make the company his agent for the carrying on of the business. So that is all I have for you for today. So in our next class, we'll then be looking at what lifting the veil is, and how you can lift the veil statutorily, how you can lift the veil contractually, and how you can lift the veil under the common law. I remain Yusuf Oluwafemi Salako, popularly known as Ori David. Nice having you. Thank you.